If you are negotiating your LOI when you are buying or selling a business, I cannot emphasize how important it is to have your lawyer on board during the LOI phase. Too often I see people come with a signed LOI with so many mistakes that already derail the deal. And I hear things like, well, we talked about these details, but we thought the lawyers can just hash out the rest. The problem is that some of the things that you've already discussed are not things that we can hash out because it's a little bit too late and it could jeopardize the deal. So one common example actually that I see, and it's pretty basic, is structuring the deal in an asset versus a stock sale. Those are two completely different types of transactions. And if that's not handled during the LOI phase, you will run into problems. So for example, in a stock sale, the balance, the books, everything belongs to the buyer. So if you have security deposits, prepaid deposits, ARs, that actually belongs to the buyer because the buyer is buying the business, it's buying the stock. If the seller wants to negotiate something that's not typical of a stock sale, they need to speak up earlier. And the purchase price is often informed by what is being bought. And the assumptions that are made going into the deal are based on the deal structure. So coming later on in the deal for a seller, for example, to say the security deposits on my lease are mine, I want them back, the buyer is going to say no because this is a stock sale and I own the books, I own the ARs. Now there are often post-closing true-ups and calculations that occur in stock sales that will account for some of these things. But if you're not discussing those early on, your deal is in a great deal of jeopardy because there will be miscommunications. People will feel like they cannot trust you anymore. They will not want to buy or sell the business. So this is why it's just so paramount. I cannot emphasize this enough to have your lawyer negotiate the deal terms in the LOI phase.